Your sponsor gets hit with a sudden illness, and suddenly your whole immigration case feels like it is standing on a wobbly chair. You start wondering if all that paperwork just becomes confetti the moment they cannot sign their name anymore. Here is the deal nobody tells you at the start. A petitioner becoming incapacitated does not automatically kill your case, but it does throw a wrench the size of a small car into the timeline. Think about it like this. If your sponsor was the pilot of the plane and they suddenly cannot fly, someone else needs to grab the controls, or that plane is not landing smoothly. For family-based petitions, if the petitioner dies or becomes permanently incapacitated before the green card is approved, immigration officials often look for what they call humanitarian reinstatement. That basically means the government can choose mercy over paperwork technicalities if you can show genuine hardship. But here's the twist that trips people up. Incapacitation is not the same as death. So the rules that apply to a deceased petitioner do not always apply the same way to someone who is simply too sick to continue. If your petitioner is alive but mentally or physically unable to continue supporting your case, a legal guardian, power of attorney, or family member sometimes has to step in on their behalf. This is where things get messy fast if nobody set up those legal documents ahead of time. Fit your power of attorney like a spare key you give someone in case you lock yourself out of your own house. Without that spare key, immigration lawyers have to go through court processes just to get someone the authority to keep signing forms and affidavits. The affidavit of support is a huge sticking point here, since that document proves someone can financially support you. If your original sponsor cannot manage their own affairs anymore, another qualified joint sponsor might need to step up to keep that support obligation solid. You also have to notify United States Citizenship and Immigration Services about the change in circumstances, because pretending nothing happened is basically asking for a denial letter down the road. Immigration cases run on documentation, and silence looks a lot like a red flag to any officer reviewing your file. Now let us talk timing, because delays here are brutal. A pending case can sit in limbo for months while lawyers sort out guardianship, incapacity documentation, and whether reinstatement even applies to your specific visa category. Doctors' letters matter more than people expect in these situations. A clear medical statement describing the sponsor's condition and prognosis often becomes the backbone of any request for special handling or exception. Here is a myth you should toss out immediately. Some people believe incapacitation instantly voids the entire petition, but that is rarely true since many cases can transfer support duties or continue under substitute sponsorship. Community stories from support forums show a pattern too. Families who prepared power of attorney documents early before any health crisis moved through the process with far less stress than families scrambling after the fact. The real lesson buried in all this chaos is preparation beats panic every single time. Setting up legal safeguards before illness strikes can save you months of frustration and thousands of dollars in emergency legal fees. So, if you are staring down a situation where your sponsor's health is uncertain, do not wait for a crisis to figure out your legal options. Do you want to learn more about how our company can help? Check out our links in the description.